Welcome to Gracefully Graying. I'm your host, Attorney Henry Gornbein. Please like us on YouTube and visit our Gracefully Graying site. Today on Gracefully Graying, I'm really pleased to welcome as my guest Chief Justice Bridget McCormack from the Michigan Supreme Court, as we discuss really an important topic that's going to be a game changer in the legal system, and that is the impact of not social media, but the impact of the COVID-19 on our legal system and what's going to be happening with regard to the use of modern technology. Justice McCormack, welcome to Gracefully Graying.
Thank you for having me. It's great to see you.
Good seeing you as well. I know you've been a guest in the past. At that time, I think you were an associate dean at U of M Law School, and now here you are on the Chief Justice of the Supreme Court. So I'm really pleased to have you. First of all, why don't you tell us a little bit about the functions of the court so we can have a backdrop as we move forward into this new era?
Yeah, it's important to understand sort of the structure and the size of state courts to put a lot of what we're going to talk about into context. So obviously everybody knows that the judicial branch is one of three branches of government, a co-equal branch. Here in Michigan, we have trial courts, a court of appeals, which is an intermediate appellate court, and the Michigan Supreme Court, which is the court of last resort in the state. Like the United States Supreme Court, the Michigan Supreme Court has the final word on the matters that make their way up the Michigan courts. And in addition to the decisions we make, we also have administrative oversight of the courts of the state. The Constitution gives us that administrative oversight responnsability. So the courts of the state means mostly the trial courts. The Court of Appeals it operates pretty independently and doesn't have the docket that the trial courts have. But the trial courts in Michigan, made up of district courts, circuit courts, and probate courts, hear approximately 4 million cases every year. That's a lot of cases when you think about one person on each side of those, and each of those people probably has family and community and neighbors that care about them and care about the outcome of those cases. And so I always say, more people interact directly with the court system than with either of the other branches of government by a factor of a lot. I don't know what the actual factor is, but it's high. And so what we do in those courts, how we do business, what we do and how we do it is really important to, I hope this doesn't sound like I'm overstating it, but I mean it, to growing faith in government. The way that we treat people, the public, the lawyers and the litigants who rely on those courts to get their disputes resolved, really has the ability to grow faith in government, trust in government, or to erode it. So we spend a lot of time in that administrative oversight role, thinking about how to support and direct the way the trial courts do business. And that work ranges from our support and training and funding of problem-solving courts, to our work on the court rules, the rules that govern how people have to handle cases, and judges and lawyers have to handle cases in courts, to child welfare and information technology. We have a lot of work that we do to try and see how we can make sure the trial courts can deliver the best service to the public. Most people, when they use courts, Henry, are not usually there for happy reasons. There are a few exceptions. We do adoptions. Sometimes people have to get married in a court or want to get married in a court. But normally people are in court because something somewhat stressful is going on in their lives. So how we delivered on our promises to them is really important.
What is your role as Chief Justice? I know there are 7 justices on the Michigan Supreme Court, and you are the Chief Justice. So explain that to our viewers.
Yeah, there are 7 justices on the Supreme Court, and honestly, we make all of our decisions by committee. So being the Chief Justice doesn't give me any extra voting power. I am still one of 7. I have some administrative responsibilities. I'm the one that schedules our conferences, and also the administrative team on the State Court Administrative Office report up to me. But frankly, even the big decisions we make on the administrative front are all made by a committee of 7. So I still have to try and persuade my colleagues when I think there is a decision that should be made, whether it's administrative or an opinion. I am one of 7. I am not special.
Chief Justice McCormack, the Supreme Court issued an order due to the coronavirus pandemic. Why don't you tell us a little bit about that and what its impact has been on our court system here in Michigan?
Yes. In fact, we've had to issue a series of orders. We might be up to 16 or 17 at this point, since the very early days of the governor's state of emergency and then stay-at-home order. We had to issue a couple of orders directing the courts how to proceed given those background orders affecting everybody in the state, as well as how to proceed to make sure we could keep the doors of courthouses open. Justice has to continue to be available even during a pandemic, maybe especially during a pandemic, but we have to be able to do it safely. So we limited in-court hearings to only those essential and emergency functions. And at the same time, we removed all barriers so that courts could conduct remote hearings. We had a little bit of a head start in Michigan. I mean, this is obviously courts across the state, across the country have been grappling with how to handle this pandemic. Courthouses are very busy public spaces, lots of people piled into small rooms for motion dockets, and I know you're well aware of that. So how we can keep people safe and also continue to deliver justice is really a tricky set of questions. We had a little bit of a head start because Michigan the Supreme Court had already bought the hardware and the software for all of our trial judges to be able to conduct remote hearings. We got Zoom licenses for trial judges over a year ago. We did that not because we saw a pandemic coming. I wish I could take credit for that. We did not. We just thought it made sense in many cases to give litigants and lawyers an option of a remote hearing. So we were lucky to have some of this in place to be able to quickly all of our court business, or a whole lot of our court business, online.
What I'd like to do is go through level by level, starting with the district courts, and talk about the impact of the use of technology, especially the Zoom technology in our courts. Let's start with the district courts.
The district courts, in a way, are the ones who have had the most difficult time getting up to speed. The district courts are the courts where misdemeanors and low dollar civil cases are adjudicated, including small claims cases. And they have the very highest number of self-represented litigants. They also have the highest dockets of all of the trial courts. So it's pretty important that we help figure out how they can do more and more of their business remotely. But because they have so many self-represented litigants, it has been the most difficult for them to figure out how to notify people that they can still continue to have cases adjudicated, but they're going to have to do them using the Zoom platform. In addition to that, the governor has had an executive order banning evictions since sometime in March. And so the eviction docket is a large docket in the district courts, and that docket has not been permitted to be heard because of the governor's order.
What about the next level, which would be the probate courts and the circuit courts, which are actually the courts where almost all the trials take place?
Yeah, that's true. I mean, there are some misdemeanor trials that happen in district courts, but the probate and the circuit courts are where felony cases, family law cases, and higher dollar civil cases are adjudicated. And they don't have the volume that district courts have, and they have a lot smaller number of self-represented litigants. So those courts have been able to adapt to a remote platform for a whole lot of what they do. Not all. Again, trials are going to be the most complicated. But they've been able to do an awful lot of their work remotely. Some judges in particular are almost current. There were early adapters to this remote platform, and they are almost current with their dockets. There is some variation. It's not learning new skills doesn't come easy to every single person, and that's okay. We're trying to help them all with the process, but but they have had an easier time than the district courts adapting to remote platforms.
Next, let's talk about the Court of Appeals, where you don't have litigants per se. You have litigants who are represented by attorneys. You have 3-judge panels who are listening to oral arguments and reading written briefs, and it seems that would lend itself very well to this technology. What has happened so far?
There's no doubt that appellate courts make the Zoom platform, the Zoom platform works extremely well for appellate courts, both the Court of Appeals and the Supreme Court, frankly. Court of Appeals maybe most of all, because with only 3 judges and 2 advocates, there's not a lot of talking over one another, and they've been able to use the platform very effectively. We've used it at the Supreme Court as well, and it's worked well there too. But as you say, in appellate courts, nobody's introducing evidence, nobody's taking testimony from witnesses, so the technology is really simple, and it's gone quite well. It's a very usable platform for appellate arguments.
What I'm hearing from, I've talked to some referees before our show, and I've talked to some attorneys, and referees by and large like it. What they're saying is you really have to be prepared. You have to have your exhibits lined up and ready to go in advance so that they can be loaded, and that way you're not walking back and forth. They're saying in a trial, a lot of attorneys will fumble and look for exhibits and take a lot of time, so I'm getting positives. I've also talked to some attorneys who are more negative. They're saying it's harder to cross-examine a witness. You can't really watch body language, though the referees are saying they can hone in on people's expressions better than if they're focusing on a Zoom than if they're watching someone in court. So it's interesting.
Yeah, I have heard lots of the same. We don't yet have comprehensive data, but we have informal data. Litigants actually seem to really like it. Obviously, they like the convenience of it, but they also feel like they have more of an opportunity to be heard. I think that might just be they feel more free to say what they want. You know, speaking to your phone or your computer is in some ways, you know, a lot less intimidating than speaking in a courtroom. That's true, especially for kids. We're hearing over and over again from judges in cases where there are children that children are much more comfortable giving information in the remote setting. But lawyers are are not quite as fond of it. I think that the ability to kick your client under the table, put your hand over their mouth, you know, some of the things that a lawyer does when they're sitting next to a client in the courtroom are impossible on the Zoom platform, and that is making some lawyers less comfortable with it. Having said that, lawyers certainly appreciate the efficiency it allows. You know, that you can appear in 2 courts in different parts of the state within 20 minutes of one another, and that, in a way, nobody disagrees that the efficiency is a big plus.
Well, you can expand your practice. I mean, think of it. If you have to be in one court, let's say in Lansing, and another court in Ann Arbor, and another court in Detroit, you can be home and you can do these all now maybe an hour apart, whereas before you'd be driving for hours. So I think it's a wonderful system for that respect. But what about jury trials?
Yeah, jury trials are going to be the hardest nut to crack. We actually just finished at the Supreme Court. We did a jury trial pilot. It's not a real case, but we have real lawyers. We did a criminal felony case. We have a real prosecutor, a real defense lawyer playing the lawyers, a real judge, Judge Switalski from Macomb County playing the judge, and we recruited jurors from family members of staff and law students, and one of the young men on my staff played the criminal defendant. And we went through the entire process. We picked the jury, we did all the testimony, we introduced the exhibits, we watched the jury deliberate, and we did it so that we can get best practices and technical support out to trial courts for those cases where people want to give it a shot. Obviously, some people won't want to. They're going to want to try and wait until a jury trial can be done safely in the courtroom or somewhere else. We have a judge in Traverse City ready to go with a jury trial in the high school auditorium. So we're going to have to find creative solutions to getting jury trials moving, and the Zoom platform might not be ideal, but for some people who don't want to wait, it might be better than waiting. So we wanted to be able to support courts and litigants who are interested in pursuing it.
I'd heard from Justice Witowski that it went well, and I got the impression that he liked it.
Yeah, absolutely. And a lot of the jurors thought so too. They appreciated the convenience and the ability to not have to drive to a courthouse, park, leave their cell phone in the car. I guess they don't have to do that anymore thanks to our rule change. But they appreciated the ability to tune in when they were needed and focus, and otherwise, like you or I right now, could then go back to other projects without having to drive back home or whatever it was.
What do you think will happen when we go back to what I call a new normal? Because I don't see us ever reverting back to where we were 6 months ago. And why don't you share your opinion with us?
Yeah, I couldn't agree more. I mean, well, first of all, when we're all going to be able to, if we could go back to where we were, I don't know when that's going to be. I mean, but assume the best. Assume there's a vaccine or herd immunity, tomorrow. Would we want to go back to the way courts operated in February or early March? And I think the answer is going to be absolutely not. We'll be able to use this platform and the remote technology for the cases or the parts of cases, the particular hearings that it makes sense to use it, and maybe for the particular litigants or lawyers who need to use it. So while it may be that it's not used as frequently for trials, it may be that it's used more frequently than in-court hearings for status conferences or motion hearings. You could imagine some of the things that happen in lots of cases that could be done far more efficiently using this platform going forward. And I've said this over and over again, now that the genie's out of the bottle, it's not going back in. People have already seen all of the benefits. I was on the phone yesterday with a judge in Kent County, and he had just taken a misdemeanor plea from a defendant who was at his job in Ohio. And he took his break. He went into the break room. He zoomed in on his phone. He took responsibility for the charges. He was sentenced and expressed all kinds of gratitude for not having to take a day off of work, drive 4 hours to do what he was able to do remotely. So, that's the kind of service we owe the public, and we now know we can deliver it. So we're going to have to keep delivering it.
Well, it's simple. It's cost effective. Think of it from a litigant standpoint. You're saving people thousands of dollars because of the unnecessary trips to the courthouse, the unnecessary drives. So I see many, many positives. If you were designing something going forward, what would you be doing? Let's discuss that.
In a way we kind of are, because the pandemic has basically forced us to rethink how we do business. We had to move quickly to just trying what we could on the fly, but now now that we know we can do so much in different and new ways, we're really gonna have to think about what makes sense to take with us. So we have a task force working right now that's composed of judges and lawyers and litigants about, what do we want to take with us into what this looks like going forward. I think the big area that we want to figure out, jury trials will continue to be complicated, but also self-represented litigants. How can we make sure that the large number of people who have to represent themselves in our courts because they can't afford lawyers, which is 8 out of 10 people in civil cases, how can we make sure that the platform and the remote process works best for them? I actually think there's lots of upside opportunity there, but we have to give some thought to that. How do we get maybe kiosks or information to people in the community, libraries, YMCAs, stuff like that?
I mean, I see it excellent from my perspective. And again, I'm not an attorney who does jury trials, but jury trials seem to be the most problematic, especially some attorneys have said, I want to see body language when I'm cross-examining a witness. I want to be close to the jury. I want to be able to when you're trying to win over a jury, personal contact is very important. So I don't know what you think of those. You said it's a tough nut to crack. So I guess.
No, I've heard that as well. There's a judge in Texas who just completed a summary jury trial. Now, a summary jury trial is really an ADR, an alternative dispute resolution process, because if the parties don't like the outcome, they can still proceed with litigation. But it looks like a trial. They picked a jury. They had evidence taken. The jury deliberated. And the lawyers in that case reported that they felt, at least in the jury selection process, that the jurors were far more forthcoming than they are in a courtroom, which is consistent with what we've heard about some litigants, kids in particular, like I was saying, that there was something about talking into your computer from the comfort of your own home, that allowed people to be more forthcoming about their feelings about the questions the lawyers were answering. So while there will be some things that are that lawyers will view as not as good as live, there might be some other things that they view as better. So, we'll have to learn. Lawyers and judges are very resistant to learning new things, doing things differently. What other industry can you think of where it's been able to resist the tech innovation the way we have? None. We've resisted it, and the dam may be breaking.
What about sequestration, both of witnesses and of jurors?
Right now we trust witnesses and jurors with sequestration orders almost all the time. We don't usually police them and have a court officer guard them and take them to a hotel. Not never, but sometimes. But often a judge just says, "Look, I'm trusting you not to talk to anybody. I'm trusting you not to do independent research," and we take their word for it. I don't think that differs very much in a remote context.
Chief Justice McCormack, on another note, last year I interviewed Justice Megan Kavanaugh and Assistant Attorney General Scott Teeter on a project that was launched by the Supreme Court and I think in the Attorney General's office jointly, looking at issues involving elder abuse in the court system. And can you give us an update on that as to what's happening? It's probably been stopped due to the coronavirus, but tell us a little bit about it.
It's been slowed, like everything else. It's been slowed, but they have a number of that task force is a big task force. There's lots of stakeholders that are working on the potential reforms for the adult guardianship system, and they have a number of proposals. They were working their way to legislative drafts, and then the coronavirus crisis slowed down the legislature. But my understanding is the legislature is now back to work and in fact is adding session days in the coming weeks. And I know the Attorney General's office and Justice Kavanaugh are continuing to work on all of those issues. Things don't always move as quickly as you want, but if they reflect more robust input, more widespread input, and we get to a better place, that's okay, as long as we do good work.
It's an important area, and it's something that's become my passion. Tell us, what are some other thoughts that you'd like to share with us? We have about 3 minutes left, and I'd really like to have your input on any other thoughts with regard to really the new technology and where the courts are going in the coming years, and any other thing you would like to share with our viewers.
We've made a number of other technical improvements that in my view are a great service to the public recently that I think are worth noting. So for example, we opened up an online dispute resolution platform in 17 counties. We partner with the community dispute resolution centers, and people can go on this platform and resolve their cases. These are low-dollar civil cases for free. They can do it before they file a case in court or after it's filed in court, and the platform will take the result of their mediation and turn it into an order and file it with the court. They never have to go to court. They can literally resolve their case on their smartphone without going to court. We're now going to have that available in 83 counties by the end of June because it's been so popular in the counties that we started it in. Another example is we have rolled out text messaging reminders for our courts send to litigants about court dates and payment dates. People, the number of people who miss a court date or miss a payment date can be costly for courts, as well as for sort of the folks that miss it, because it causes bigger problems. And it turns out that the single thing most likely to predict whether someone comes back to court or makes a payment on time is whether they get a text reminder. So we now built a platform to be able to allow the courts to send those text reminders, just like your dentist does. So there are lots of ways that courts can use technology to really serve the public better. And I think it's our job.
We're running out of time. Chief Justice McCormack, I really appreciate your coming on to Gracefully Graying. This is so informative and so pertinent right now, based upon what we're going through and the fact that there's a new world. And it seems like in Michigan, we're going to be on the cutting edge of technology in the legal system, which is a very good thing. So again, I want to thank you so much for being my guest on Gracefully Graying. And I want to thank our viewers for watching Gracefully Graying.